at 7 o'clock, so I think we can go ahead and get started. So let's begin. I think an attendance sheet should be going around. If you haven't turned in your drafting assignment, the second drafting exercise, you can go ahead and do that now. We're going to spend some time reviewing those too. I mean, if you, hopefully if you turned it in, you also have like a hard copy that you're looking at, because we're going to spend some time going over that. You might also have an electronic copy, because we are going to spend some time looking at that. The game plan for today, if you look at the syllabus, which it hasn't exactly been updated, but it was already updated. The game plan for today really is just to review the drafting exercise, which kind of gets us thinking, brainstorming about how, not so much to draft a complaint, but to kind of assess a cause of action, analyze a set of facts with the thought in mind that maybe down the road you're going to have to draft a complaint, and indeed that's what you're going to have to do for next class. So we're going to review the drafting exercise as the syllabus notes. Just talk a little bit more about complaints, but really kind of turn our attention pretty quickly to the next drafting exercise, which will be due by this Saturday at 5 o'clock. And that exercise is to review an assigned case file. It's substantially the same file that you read before. I've edited the Portia Pond fact pattern a little bit. And what you're going to ultimately have to do is draft a complaint based on that fact pattern. But to begin, I thought we would start, and then that'll be the drafting exercise for next class. Of course, the reading assignment will be new as well, and that will focus on answers, right, which is also known as defensive pleadings. And so you will finish the drafting exercise by Saturday at 5 o'clock. That will be drafting a complaint, and then you'll turn your attention to the reading exercise on answers, which will give you about 48 hours to do that. It's not too long. And we've already kind of introduced that concept a little bit as well. So for any questions about where we are, where we're going? It might be a lighter hour. I mean, I don't think we're going to go to the full time, just because I don't necessarily think we need to. Let's just see how long we go. I'm also kind of battling the cold, so if I constantly am kind of doing this and sniffling, that's why. Let's look at the drafting exercise that you did, drafting exercise number 2. So this is the slip and fall premises liability. It says complaint, but it's really nothing more than just a fact pattern. And you'll recall the fact pattern says that your client is named Portia Pond, and she runs a cleaning business known as Old Town Commercial Cleaning. On November 1st, 2019, Portia was injured while she was performing janitorial services at Grantham's Jewelry Store, which is owned by Philip Grantham. Your paralegal recently interviewed Portia and learned the following facts. And it sets out a number, kind of a paragraphs just laying out some allegations with respect to this slip and fall on the 5-gallon bucket of jewelry cleaning solution. There were, in reading over it again, I noticed that there were a few things that I think made it a little bit of an ambiguous kind of gray. People are applauding us there. They love Portia Pond. It's a little bit of a gray fact pattern, and I try to clean up some of that. We'll talk about some of the ways I edited the fact pattern at the end of class. But what do you all think? Let's go in order with some of these questions. I mean, some of these have a right and wrong answer. Some of them don't. But you'll see attached right there was the memorandum, the practical effect of Kentucky Rules of Civil Procedure, rules on pleading practice. The kind of big takeaway there was we're in a fact pleading state, and just this idea that if you're going to ultimately draft a complaint, you want to have factual allegations that go to each of the elements of the cause of action, which is listed at the end of this memo. But that's kind of the big takeaway with the pleading jurisdiction. It lays out some of the information on the jurisdiction of the courts, like when does the Superior Court have jurisdiction, when does the District Court have jurisdiction, and some of the amounts there. It's got a little bit of information on the long-arm statute. We've got some information on venue, the fact that damages that Kentucky law prohibits stating the amount of damages in the complaint and pleading punitive damages. It's got rules on signing and captioning, which will become important when you actually draft a complaint. And then, of course, the elements of a premises liability cause of action, which I have edited just a little bit to make it a little bit more clear. because I think the way the first paragraph's written kind of leaves it open as to whether or not a business owner would owe a duty of care to somebody like an independent contractor. I thought that was confusing, and we'll talk about it at the end of class. I kind of clarified that that is in fact the case. But in any event, since we're not, for this exercise, we weren't supposed to draft a complaint, we were just supposed to answer these questions, I thought we could just go through some of them and see what you all thought. Because ultimately, this is a very realistic scenario. I mean, it's not the most realistic. I mean, your practice is going to certainly look a lot different than this, but you want to start to think about, gathering facts, being presented with a kind of a fact pattern, and thinking, what are some of the questions I'm going to want to think about in preparing to draft a complaint? And these, I think, are some of the questions. So let's look at this assignment B. And I'm just going to take volunteers, and so that when nobody volunteers, I'll call in people, which will probably be the first question. No, you guys can volunteer. Or let's look at assignment A, excuse me. What about this? Assignment A, assess the cause of action. After reading the memo and the facts above, answer the following questions. 1. Do you think you have sufficient facts to establish a cause of action in Kentucky? What do you think? Come on. Make a volunteer. I was just kind of joking that nobody would yet. Tell me again.
April.
April. Okay, good. Why? Yes, why?
Because basically, in order to have a cause of action, we just need to, there needs to be an injury of some kind, like a harm, and money owed. I mean, that's not, under the 4 things that are laid out, that's kind of a broad way to look at it. But I think that there's enough facts for us to just say, this happened, she was hurt, they owe her a duty, and now she's owed money.
In thinking about whether you have sufficient facts to establish a cause of action in Kentucky, what 2 things are you looking at? The one, I'll give away the one. The one is the fact pattern, right? You're looking at that, and then what are you comparing that to?
The elements of the cause of action?
Yeah, and where are those?
In the world.
Well, in the world. No, that's right. I mean, most
kidding.
of the time they're not going to be spoon-fed to you, right? You're going to have to go out there and do legal research. For our purposes, though, it was at the end of the memo, right? But you've got to figure out, like, hey, what is the landscape here? What causes of action could this person potentially assert? You've got to, it's true that in reality, you're going to have to do Westlaw research or Lexis or whatever it is, figure out, employment discrimination. Okay, what do you have to do to prove up employment discrimination claim? 8th Amendment deliberate indifference to medical needs claim. I've got this miserable one on my desk that I can't get through. It's so awful. First Amendment claim, whatever the claim is, you got to figure out what are the elements of the cause of action, and do I have enough facts to meet each of those elements? So, tell me it again. April. I mean, just drill that in. April. Okay. Let's look through each of the elements, April.
Okay.
Walk through it. What facts do you have in the fact pattern? What facts tell you that there's a duty of care here owed?
Well, I got really kind of tripped up.
Well, that's fair. That's kind of where I got tripped up too. And why?
Because she's not really an invitee.
Yeah, I think that is kind of a defect with the problem, and I fixed that. I'll talk about that at the end. But yeah, I mean,
I just assumed for the purposes of answering it that you wanted us to act like she was.
Yeah, I think that's fair. I mean, it's true that if you look at this law and you see that a person who owns or is in control or premises or possession of premises has the duty to use reasonable care to make the premises safe for a business invitee, the question then becomes, who is a business invitee? And the law here defines it as a person whom a commercial entity invites onto its premises in the hope of gaining that person's patronage. And when I read that, I think of customers, not independent contractors who you've hired to do cleaning. So I changed that in the complaint. But assuming that that is met, yeah, did you have a question? Yeah, please.
I think for me, the reason why it's difficult was, I like her, was like, oh, he probably wants us to go along with the duty of care.
Yeah.
But for me, it's complicated because, going through what you spoke about last week, the sequencing was off. There was no real introduction of this is who these people are and this is their relationship before going into the rest of the fact.
Yeah, now that's fair. I do think though, when you're presented with a fact pattern, it's very common that you may not be given facts that line up with like, oh, here's the nature of the relationship between the parties, here's who they are. You know, not everything is like, once upon a time there was, I don't know, now I sound like I'm being an asshole and flippant, which I don't mean to be. But I think that's a skill, which is taking a jumbled set of facts and figuring out what in this page or, you know, multiple pages of facts goes to the element of duty, what goes to breach. And it might be mixed up. So I think that is a fair skill that you're going to have to kind of learn how to tease out a little bit. But I do think you're right that the nature of whether or not there was a duty of care owed isn't really clear based on this law. So I think both of your points are well taken. But assuming that Portia Pond is a business invitee, then we would assume that the duty of care is owed, right? Because you've got an owner of property, an owner of a business, you've got someone performing services to the business owner as a cleaner, you know, a janitor, and that's under the laws, we're assuming that that's a business invitee. Therefore, a duty of care would be owed, right? What about breach? What do you need? What sort of facts go to the element of breach? Well, you need first, April, the existence of a latent hazardous condition. You got to first kind of tease that out, right? Because there's a lot there. You need the existence of a latent or hazardous condition that the defendant either knew of or had sufficient time to become aware of. So the first thing you're going to want to do is break down, was there a hazardous condition at all?
Yeah.
And what was that?
The spill.
The spill, right? Yeah. The fact that this cleaning solution had spilled on the floor. I mean, that clearly is a hazardous condition. I mean, I think you have enough there that you can at least allege there is. Then you need the defendant either knew of or had sufficient time to become aware of it. I've tried to clean up some of these facts, but what do you think about this, just based on the fact pattern is
I
given?
think that it fits still because she had told the manager.
Yeah, she told a manager who we would think just, you know, in a kind of a brainstorming exercise, that person is someone who presumably is in contact with the owner, right? And is someone that, you know, he's kind of on duty to be aware that, you know, if the manager knows, it's kind of imputed to him. Something like that, you're just thinking out loud. So you've got a hazardous condition. He either knew of it or at least had a sufficient time to become aware of it, right? So I think that you've got some facts there. Who else wants to help us? What about this? And defendant failed to remove, repair, or otherwise correct the condition. Yeah, tell me your name.
Mitchell.
Mitchell.
I mean, I think by the fact that, like you said, the manager is in a position to where either A, he or she can fix it, or B, they can tell the owner,
Exactly.
would get someone to fix it, and the fact that there's been multiple instances of seeing it and then reporting it, and the fact that she once again slipped on what was there, that the facts alone.
Yeah, those facts all go to this idea that he failed, the owner failed to remove, repair, or correct the condition. Or, right, so you got those facts. What about failed to make reasonable efforts to warn the plaintiff? Well,
honestly, I think all you would need to do is just put like a slippery, you know, wet floor sign right over on that side of that area.
Yeah.
She's warned.
yeah, well, totally. And what's interesting about these facts is they're not in there, but I think almost the lack of facts is beneficial to you. There's no indication from these facts, as people are plotting your answer. It was an excellent answer. There's no indication from these facts that people made a reasonable effort to warn her or anyone of the hazardous condition. So I think you've got some facts there. What about breach? Causing the plaintiff's harm. I've cleaned that up too. I mean, it really, causation includes both but-for and proximate cause. But if you're just thinking about causation generally, did this alleged breach cause her harm?
I'd say so. I mean, even if you want to go to the but-for the floor being wet or the floor causing her fall, she would not have broken her hip and broken her
Exactly.
legs.
Yeah, I mean, she would never have been injured if it wasn't for this spill, right? And certainly it was foreseeable that something like this would happen. The zone of the whatever test that exists within proximate cause nowadays. But yeah, it was certainly foreseeable that someone would be injured when you repeatedly leave the floor in such a slippery condition. And as a result of the breach, she suffered damages, and those are kind of clearly spelled out in the fact pattern. Doesn't mean it's a perfect perfect case. Doesn't mean there aren't defenses that are available. Doesn't mean that a defendant might not be able to admit or deny certain allegations. What did he know? When did he know it? Did he talk to the manager? How present of an owner is he? But we're thinking about just drafting a complaint, and the point of this isn't, you're probably thinking to some level, it's not really that hard, right? I mean, you got enough here. But the point of this is really to kind of think not so much about how do I kind of discover elements of a premises liability complaint, or how do I dig around and find facts? It's really to kind of recognize that in drafting a complaint, it's a technical way of writing in the sense that you really want to focus on ultimate facts, gather some of these ultimate facts, and then write it in a way that's neutral and that is broken up so that you can glean information from the defendant. And we're going to talk about that as we actually think about drafting the complaint. But I think, April, you're right, and I think, Mitchell, you're right as well, that you probably do have enough facts here to establish a cause of action in Kentucky for premises liability. What about number 2? Which court would have subject matter jurisdiction over the action? Why? Who wants to help us with that? Yeah.
Hannah.
Hannah, okay.
Assuming that the damages are over the jurisdiction amount, 'cause that was not listed in the memo, but since she had surgery, you can kind of assume that's going to be more than $20,000.
I think that's fair. Yeah, I mean, it sounds like we're at a debate here, and we're like, how much is the cost of healthcare? It's out of control. I mean, I think that's right. I mean, yeah, there's a lot going on here factually. I've cleaned that up too to make it even more obvious. But yeah, I mean, I think multiple surgeries, broken hip, broken arm, what else did it say? It said, she may never walk again, or may have to use a cane for the rest of her life. I mean, yeah, $20,000 is a pretty low amount. I can think you would almost certainly be over that jurisdictional amount. But if you can't plead the specific amount, how would you allege it? Any ideas?
How I've seen it, when we do it at work, we can't plead the jurisdiction, you can't put the amount in there, so you just say, this cause of action meets the threshold limit of
Yeah.
the Caledonia County Superior Court.
Exactly, yeah. Or you could, I think the safest thing to do would be to say something like it exceeds $20,000, right? Just so it makes it clear that you're over whatever the threshold is to get into what court? The Superior Court, not the District Court. What about venue? Any reaction to that? Can the action be filed in Caledonia County? Why or why not?
I said it could, because that's where the cause of action.
Yeah, that's where the cause of action occurred. Sure, of course it could. Yeah, what about number 3? How many potential defendants do you have, and what was the basis of each potential defendant's duty? It's not really a trick question. Yeah, what do you think about that? How many defendants?
I don't know if there could possibly be 2.
Maybe you could think about the manager. The problem is, though, you've got to think about whether the manager owes the plaintiff the duty of care.
Maybe he would be someone that the owner could possibly bring in as a third party then, because he's the one who really knew about it. But the person who he would mainly sue would be the owner, because he would have the duty of taking care of his shop and making sure it was safe for the business invitees.
Yeah, I think it's pretty clear, and I've even tried to clean that up too, to just streamline it as much as possible. Really, you just want to be focused right now, for our purposes, on the one defendant, and that's the owner. And of course, the breach is the failure to either, warn of the hazardous condition or fail to remove, repair, or otherwise correct it. What are the ultimate facts? We've already talked about that. What weaknesses do you think exist in the case? Yeah.
We already talked about the biggest one is that we still don't technically know whether or not,
Yeah.
at least based on the facts that in the memorandum that we were presented, whether or not an independent contractor constitutes a business invitee.
Yeah, that's one.
So, if that isn't there, or if it doesn't constitute a business invitee, then the claim fails altogether.
That's
Not that
true.
it wouldn't, get passed and go into, the complaint, that would just destroy the complaint in general, but it may ruin your case over that.
Let's tease that out, though, okay? Let's say that you're right, you're representing the defendant, and you find case law that says that independent contractors who come and clean your business, those are not individuals to whom you owe a duty of care. What are you going to do if you're a defendant and you get a complaint that makes some of the allegations along the lines of like April's talking about or Hannah?
I'd probably filed to dismiss, for lack of a claim upon which relief can be granted.
Yeah, failure to state a claim, right? Because even if it's true that all of those allegations exist, right? I mean, even if all of those allegations are true, the plaintiff hasn't stated a valid claim because of duty, right? The element of duty is not met, and you need duty, breach, causation, and damages. So that would be a 12b6 motion, which is something we're going to talk about after we get to answers, right? In thinking about civil litigation, right, we're trying to not lose sight of the big picture here, which is you kick off civil litigation by filing a complaint. The responsive pleadings typically it's an answer, but you can also get a motion to dismiss for lack of subject matter jurisdiction, 12b1, a motion to dismiss for lack of personal jurisdiction or improper venue, or 12b6, a motion to dismiss for failure to state a claim upon which relief may be granted. Even if all of these allegations are true, the plaintiff hasn't stated a claim, and here's why. What other potential weaknesses exist beyond just maybe legal deficiencies? Yeah, tell me again. Kirby.
Yeah, Marcia O'Shea cleaned it up 3 times previously. She had actual knowledge of the risk. So, I mean, the complaint, not, but later on, that would definitely pose some problems.
But I think you're 100% right. And how would you characterize that? I mean, put your kind of torts hat on, and you're thinking about defenses in a negligence cause of action. What would you call that, arguably?
Something causation, like not intervening, but like it would like make her causation argument difficult to say approximate cause, like her own negligence, like she was aware. I can't think of our word.
Why? It's interesting. No, that's okay. I think what you're thinking of is how does it undermine the cause of action, right? Because when you're thinking about litigation, you're thinking about what facts go to the elements of the cause of action, and do we have enough to kind of get past a 12b6 motion? But a defense would kind of be like, hey, even if all of these things are true, the reason why she doesn't recover is something else. Yeah.
Assumption of risk.
It could maybe be a little bit of an assumption of the risk, depending on kind of some of the theoretical things. You might also think about maybe contributory negligence or comparative fault. Like, to what extent is she at fault? For assumption of the risk is probably a better fit for it, right? Because you knowingly kind of assumed a risk when you entered into a room that has repeatedly had a hazardous condition. But maybe there's some sort of, to some extent, she was negligent. You also wonder, and these facts are outside the scope of the problem, but you also wonder the extent to which somehow she's responsible for the condition. I mean, if she's responsible for making sure that it's cleaned, like, it's a little bit of the chicken before the egg. So none of it necessarily is a perfect fit, but you might start to think about, hey, what are some ways that we could, as a defendant, undercut the plaintiff's claim, not so much by attacking the elements of the cause of action, but also thinking about affirmative defenses that could exist. Yeah.
And I guess that would affect how the plaintiff, like, you kind of like, you almost have to acknowledge that she told the manager 3 times that it was there, but like, how do you say that without being like, I literally cleaned it up myself 3 times?
Yeah, I mean, I think that's fair. I think you have to, there's nothing wrong with thinking about in the back of your head, as I plead this, what are they going to come back with, right? I mean, I definitely think you want to have that in your mind, but that's also why you're benefited just by pleading it in a neutral way. Like, to some extent, when they come back, if they're going to come back with a motion, then you're going to get into a little bit of a legal argument. And so I think when you're thinking about drafting a complaint, you're really kind of most focused on the ultimate facts, proving up each of the allegations of the cause of action, and hoping that that survives a 12b6 motion. And if you can do that, defenses are something that they're going to kind of have to affirmatively plead. So you want to have it in the back of your mind, like, am I pleading this in a way that opens me up to them having a viable defense? But on the other hand, you're also just kind of recognizing that if they are going to plead a defense, they bear the burden on that. So I wouldn't be too concerned with you pointing out a latent condition as necessarily meaning that they're going to have an open and shut affirmative defense. And certainly for our purposes, what you want to be thinking of is what are the elements of the cause of action, and in a very kind of neutral way, how can I allege ultimate facts that go to each of these elements? And it may seem very kind of elementary, but in a way, that's what you want. You want to simplify it and match up facts with elements, okay? All right, what about assignment B? Let's take a look at that. This amazing complaint that existed. You find a premises liability complaint in your firm's files set out below. Review the list of elements set out in the memo. Review chapter 1, review chapter 2, which are the 2 reading assignments you've already done, and then answer the questions. Does the complaint that's attached contain a proper caption and jurisdictional statement? What do you think? Caption? In Kentucky. What do you think? No, Kirby, why not? What am I looking for?
What court it is in.
Yeah, exactly. Not in Kentucky. That's insane. That's an insane caption, right? You would want something like in the Superior Court, Caledonia County, Kentucky. United States District Court for the Western District of Kentucky, right? Federal Court, Western District. Not in Kentucky. No, it doesn't have a proper caption. What about the jurisdictional statement? Where is the jurisdiction? Well, let's just dissect this a little bit. This thing sucks, right? It's terrible, right? This is also different than last semester. FYI, like we used the Portia Pond thing last semester, but I've edited it. Similarly, I used this thing last semester, but this one's different too. This is way worse than what we looked at last semester. This is awful, right? What else is wrong with it? Just looking at the caption, right? In Kentucky's wrong. You'd want to say something like in the Superior Court. You would want to say something like in the Superior Court. And of course, that's if it's the Superior Court. If you're in the District Court, then you would say that. Yeah, April.
I think it's weird that it's got plaintiff versus Blue Lake. It should, the plaintiff's name has to be there. At first I was thinking it could be plaintiff versus, it needs to either be plaintiff and defendant, but that's just weird. It needs to be name versus name.
Yeah, exactly. You should have something like, now this one's different, defendants, plaintiff and defendant, but something like Portia Pond, comma, doing business as Old Town Cleaning Services, comma, plaintiff, right? Versus Philip A. Grantham, comma, doing business as Grantham Jewelry, comma, defendant. Or here it would be plaintiff Susan Braintree versus defendant Blue Lake Club. And whether you do like name, comma, plaintiff, or plaintiff Colin Schuler versus defendant University of Kentucky for unpaid bills, no. For paying me a wooden nickels to teach over the summer, no, it's a joke. But you know, whether you do plaintiff versus defendant and then put the name after that, I don't have that strong of a preference. That tends to be kind of local rule. I kind of like the idea of saying like plaintiff, I mean the markers here, plaintiff us versus the Louisville for not having markers. I like the idea of like plaintiff Patty Smith versus, you know, defendant John Doe. The key is making it consistent. If instead you do, like when I write things in court, it's plaintiff, or it's Patty Smith, plaintiff, versus John Doe, defendant. I mean, we could get super technical. To be honest with you, I mean, that's not the point of this class. The real point of this class, honestly, I mean, I don't like this stuff as much. I like the later stuff, the memos, the judicial opinions, I mean, this is good. This is what we need, but I'm not like, I'm not going to be a stickler on like, oh, you had this, 6 parentheticals instead of, you want it to look right. Like, you definitely want the right caption. Whether you do plaintiff first or defendant first or it comes after, the key is that it's consistent, right? You need a name. You need the word plaintiff to be here, but it's got to be consistent. There's not one right way to do it. There's a wrong way to do it. There are multiple right ways to do it, and there are a lot of wrong ways to do it. Does that make sense? Do you know what I'm saying? Like, this is totally wrong for the reasons April suggested. Like, plaintiff is just plaintiff who? Versus, and then the word defendant's not below. It just says Blue Lake Club. So you would want to make it consistent. Either plaintiff Susan Braintree versus defendant Blue Lake Club, or Susan Braintree, comma, plaintiff versus Blue Lake Club, comma, defendant. Something like that. The case number looks, I think, okay. Judge, you might need the full name. That kind of is a jurisdictional thing. You know, it depends on the jurisdiction and what the local rules are. But so yeah, the heading is totally wrong. This is set up wrong. And then the complaint, I don't know that you would title it the complaint. You might say complaint or premises liability complaint. For ours, I would do something like complaint for damages, premises liability, or premises liability complaint. Not the complaint, just sounds stupid. Like, well, of course it is, right? Better to just say complaint. What about this intro? Back to you, Kirby. What do you think about this intro?
Not great.
What's that?
Not great.
It's really bizarre.
Yeah.
It's almost like socially bizarre, more so than me, right? And now comes Susan Braintree. What? Like what? Who talks like that, right? And now comes Susan Braintree, also known as Braintree, or hereinafter Braintree. No, just say Susan Braintree, plaintiff Susan Braintree sues defendant Blue Lake Club and alleges, something like that, right? None of the AKA hereinafter, blah, 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 that's all nonsense. You don't need that, okay? What about number 1, the jurisdictional amount? What's wrong with that?
I don't think, they don't indicate which court in particular. They just say this court has jurisdiction matter. And I don't think it's appropriate. I mean, I don't know if you should abbreviate Kentucky or not. Probably not. You gotta go from those.
Yeah, it's all weird.
Yeah.
This action is for damages, period. The matter in controversy is for damages in excess of $15,000. Well, first of all, isn't it 20? Did I just have a stroke? Isn't the $20,000 the key thing? Yeah. So first of all, like that's wrong. 15,000. I mean, but we don't even know what court we're in.
Yeah.
So maybe it is fine. I mean, so what you would want to say is something much more streamlined, like this action is for damages in excess of $20,000. That would get you there. And again, remember that the point of this citation of Kentucky law, really, the Pent law, first of all, is that even the right abbreviation? Nobody knows. Right? It's not what Pent law? What? But more importantly, you don't even need the citation of the law, right? I mean, the complaint is supposed to be alleging ultimate facts that, if true, would meet each of the elements, not only of the cause of action, but here the jurisdictional element. So something as simple as this action is for damages in excess of $20,000 would be enough to provide a valid jurisdictional statement to get you into the Superior Court of Caledonia County. Is there a proper commencement? I think we've already kind of established that it's bizarre. No. You would want to say something like plaintiff Susan Braintree. I would say something like plaintiff Susan Braintree sues defendant Blue Lake Club and alleges : what about this? Is it properly signed?
No.
Who wants to help me out with that one? Is it properly signed? I mean, obviously, it's not signed, but I mean, what do you think about this? From Adam Colchester, the attorney. Yeah, tell me your name. Amy. What do you think?
So it's definitely not properly signed. In the requirements, it says that they need a firm's name, attorney's state bar number, the attorney's firm, address of the office, the phone number, or email.
Yeah, I mean, I am going to be technical for those things. I mean, when I say I'm not going to be a stickler for certain things, if it's not contemplated by the rules and there's a little bit of flexibility, what you put first, what you put second, that's fine. But if the local rules say you've got to include all these things and you don't include any of them and you don't sign it and you just write from, first of all, it's just bizarre. Love, Adam. What is going on here? Like, oh, anyway, I was going to say a joke about Chase, but I won't. I always pick on another law school that I offended a student. So anyway. It's ridiculous. It's absurd. Okay, so you wouldn't write from Adam Colchester. You would include kind of a block here that lists all of the things. I mean, it wouldn't actually be in a block, but it would list the address, the bar number, the name of the attorney, all of the things that are contemplated by the local rule. You would want to include, for example, and also, of course, the signature block would actually have a line where it would actually be signed. For you all, I don't mind it since, you don't have to feel like you have to print it out and then scan it in or anything. You could just do something like this, just to let me know that you would sign it. Or some people like to get cute and then they find a different font and then they write their name. And I'm like, oh, well, that's kind of creative. But the point is you would actually have to sign it. Is the jurisdictional allegation correct for the court? Well, we don't really know because we don't know which court this is in. I mean, if it's in the district court, it would be fine that it would be alleging more than $15,000, but that would actually be superfluous. All you would need to be alleging is more than $5,000. So it's not clear if it's the superior court like we think it is. It's not correct. It would have to be more than $20,000. What about number 4? Amy, what do you think about that? Does each paragraph deal with a single element?
I say that they don't.
No, this is awful. This is so bad. Don't use this as a template, right? What's going on here? What's number 2 about?
That was my example that I used. It contains a statement of jurisdiction and also states what type of business is conducted there. It states all the different things that probably could be separated out.
Yeah. 3 is a disaster, right? And in that location, first of all, it's also written so poorly. Look at this. On September 9, 2003, and in that location described in the previous factual allegation, you don't need that. The defendant had suffered a film of soap.
That was confusing.
Yeah, that confused me.
I have no idea. I agree. It's totally confusing, right? Doesn't make any sense. And it certainly doesn't limit to one element. Had suffered a film of soap and water to be and remain upon the tile floor of the women's changing room in the area beside the locker where Blue Lake staff had been mopping the floor. That is one sentence that is stunningly bad. On information and belief, which I hate, that exists in the law a lot. On information and belief, just allege it. It's on information. What if I came in and said, on information and belief, we will do an assignment next class? We'd be just say we're going to do an assignment next class. On information. Who talks like that? Don't become a weirdo just because you start typing things. That's my official advice. Don't become a weirdo. But people turn on this I've got to talk in a legalistic way when they start typing a complaint or any sort of legal document. If it doesn't sound like something you would say, hereinafter, you don't say that. Heretofore, you don't talk like that. That's the legalistic language that we don't need. And in fact, it runs afoul of the principles of good legal writing that we've already talked about at length. So no, certainly each paragraph does not deal with a single jurisdictional element. And in fact, paragraphs like number 3, number 6 are bearing a lot more in there than you need. Even things like this, on information and belief, defendant knew or had sufficient time to become aware of the aforesaid hazardous condition of the tile floor. Blue Lake's negligence caused her slip, fall, and severe injury. You've literally got multiple ones there. Causation, damages, not to mention just the legalistic language that doesn't involve just ultimate facts. They're going to deny that allegation. If a defendant gets this complaint, especially with number 3, they're just going to immediately deny the allegation. And you will have gotten nothing out of that. You will have learned nothing from that entire thing. A denial can be beneficial under certain circumstances. If it's a discrete issue and they deny it, you're like, oh, that's contested. That's fine. But if you just dump a bunch of words in a paragraph and then they deny it, you haven't gotten anything out of that. Okay. Number 5. Is each paragraph consecutively numbered except the commencement and demand for judgment? Let's keep going around. So we got Amy. Who's next? Tell me your name.
Mark.
Mark, what do you think about that? Is each paragraph consecutively numbered?
It looks like it.
They've got that going for them. They know how to number, right? Woo! All right, yeah, we've got that. And that, we kind of joke, but that is something you are going to want because at least when you're drafting your complaint and you've got consecutively numbered paragraphs, what you're then looking for is an answer that responds to each of the numbered paragraphs. So, that is a valuable thing to have. The question is what's in the paragraphs. Go to the next one. Does each sentence set out ultimate facts? We've kind of answered this, but what do you think?
No, not at all.
No, and what specifically is the problem? What is included?
Like the words negligently.
Which are what? legal conclusions, right? Those sorts of words are going to lead the defendant to immediately deny that factual allegation. Does any sentence contain evidentiary detail, extraneous details, or conclusory language? Yeah, I mean, I think most of these do, right? I'm not sure why disability has a hyphen in there. But yeah, hospitalization does too, interestingly. Treatment, yeah. I mean, I love number 5. Plaintiff slip fell and was really badly injured. Among other things that she suffered, she broke both legs. Can you believe it? Yeah, that's pretty shocking. Okay, what about number 7? Is the language in each paragraph clear? No, I don't think so. Is it free of needless jargon? No, it's full of needless jargon. Do the sentences focus on the actor, except when strategic considerations require a different focus? What do you think about that one? What do you think? Tell me now.
Kyler.
Kyler?
Kyler, yeah.
Okay, what do you think about that one?
No.
No, and why?
I mean, it jumps around.
Yeah, it jumps around. I mean, part of it is you want to try to, as best as you can, I think, use the active voice and focus on specifically what each person that you're alleging engaged in conduct, what they did, that sets out an ultimate fact. Are time and place sufficiently clear, Kyler? What do you think about that one?
No, I mean, the only really date they listed was in paragraph 3.
And why might that be problematic? When you don't remember, you only want to kind of allege dates. I wouldn't say it. Dates don't always have to be alleged, right? I mean, if the date isn't critical, it's not like you have to have a date on every allegation. That's not necessary. But why might a date be important if there's an issue about what?
When the injury occurred, I mean,
yeah.
I just feel like there's a lot of facts going on here for one date to be listed.
Well, that's true, but I mean, when might the date become an issue? Any thought? It's kind of a poorly worded question, people.
I'm just thinking that when the defendant gets it and they see it, if they don't really know about what happened, it's going to be easy for them to deny it. They're going to say they don't have sufficient information.
I think that's fair, yeah, especially if you're talking about a kind of a concrete, like, slip and fall event. That's possible. What's another thing, Kyler? What if I changed the date on September, what is it, 3rd?
9.
I'm sorry?
9, 2003.
Okay, what if I said on September 9, 1993?
That's quite a long time.
And what's the relevance of that?
Statute of limitations.
Yeah, I mean, if it looks like there might be a statute of limitations issue, the date becomes important. At some point, you're going to want to kind of make it clear when it happened. I think, it ought to be clear somewhere in your complaint when the significant events occurred. In our complaint, when everything kind of gets set in motion on November 1st, 2019, as long as you kind of make it clear towards the beginning of the complaint, somewhere that, Portia Pond went to Grantham's Jewelry to provide cleaning services on November 1st, 2019. On that date, this is what happened. And then it kind of, the rest of it flows. Then you're going to avoid any issue like, I don't know when this happened, I lack sufficient knowledge, or you run into a potential statute of limitations issue, which can certainly exist. What about 10? Does each paragraph, we've already talked about that, is the terminology in the complaint used consistently? And the answer to that is no, and that we've already kind of talked about that. I think that honestly tends to be the key more than anything. I think there are a lot of areas of the law in legal writing just generally, whether it's drafting complaints or answers, kind of technical documents, motions to dismiss, or in the documents that I think will be more enjoyable to you that provide you with a little more leeway, like drafting a memo or drafting a judicial opinion or drafting some sort of a form of expository type writing where you've got some more leeway. I think there is room for how you write, and I think the key for a lot of this is consistency. you know, if you're gonna number things, number them the same way. If you're gonna use subheadings, you know, don't have a Roman numeral 1 that's defined that has words here, and then a Roman numeral 2 that doesn't, right? Make sure if you're using A, B, C, it lines up, it matches, the headings are proper. Consistency, I think, can go a long way in drafting documents, and I think the same is true with respect to complaints. Any questions about this? Was this at all helpful? Does it get you kind of thinking about drafting complaints? I want to look now, if you can, as the computer goes dead. I want to kind of take a minute. Louis, let's see. No, are you serious? Like, Louis Brandeis, I get it. That was my attempt at humor. Okay, look at the drafting exercises and go to the new one. Let's talk about it. Let's just spend some time talking about what we're going to have to do here. So I've edited, here, if you click on this, do you guys have it open? Are you able to open it? No? Yes? Let's look at, first it's the drafting exercise. It always is better to download it. Looks like I don't know how to type. Open it, it looks better. Okay, you're a first-year associate at the law firm of Romford, Guilford, and Colchester in the city of Oberon, Kentucky. Please review the updated Portia Pond fact pattern, because we've updated it. I'll talk about that. And the memo titled Practical Effect of Kentucky Rules of Civil Procedure, which has also been updated. Also, please reread the material regarding the general introduction to litigation-related documents and the initial pleading. Those are the 2 reading assignments we've already done. Then draft a 1-count premises liability complaint that meets the requirements of Kentucky law. Okay. Now notice the address of Romford, Guilford, and Colchester isn't there. You can use your, law school address. You can make up a bar number, those sorts of things. I'm kind of more, frankly, concerned with the kind of meat of the complaint. But let's look at this case file, which includes the new, slightly updated fact pattern. Okay, slip and fall premises liability case, Portia Pond fact pattern. Looks a little different. Your client is Ms. Portia Pond, an independent contractor who owns and operates a cleaning business known as Old Town Commercial Cleaning Company. Since 2015, Portia has performed janitorial services at Grantham's Jewelry Store, which is owned and operated by Mr. Philip A. Grantham. On November 1st, 2019, Portia went to Grantham's Jewelry Store to clean, but was badly injured. Your paralegal recently interviewed Portia and learned the following facts. Okay, A. While Portia was cleaning the jewelry store, she went into the employee break room, one of the areas Portia had previously agreed to clean. So, it was kind of interesting to me. I'm being a little more paternalistic with this fact pattern, but a part of it is because I was thinking one of the issues with the last one was, was she supposed to clean the break room? Like, it wasn't even fully clear to me that she was supposed to clean that. I think if you've got that fact, right, maybe this is like you've gotten more information from your paralegal. You also, another defect even with this fact pattern is, you also, hopefully, I don't know, I don't practice civil litigation. You all probably would know better than I do. I've never been a plaintiff's attorney. Are people drafting complaints without meeting their client? No, I don't think so. I think you're meeting your client. I don't think you're just like, paralegals are good people, right? But you're not like just saying, oh, hey, paralegal, you met with this prospective client. Give me the info, and I'll just draft a complaint. No, you're relying on this and your own interview with the client and the documents they gave you and pictures they gave you and x-rays they gave you and medical bills they gave you and the mom you talked to who's like, Portia's been down. It's all of that, right? I think so, right? I'm not, a plaintiff's attorney, but I think it's more than just your paralegal. But anyway, we're presuming you're getting more facts here. And one of the facts I think you'd want to glean is, hey, is this an area you were kind of supposed to clean? And these facts make it clear that they're one of the areas Portia had previously agreed to clean. I think that's something you'd want to include in a complaint, right? So that's there. However, as Portia went inside the break room, don't worry, she still slipped and fell in this fact pattern on the jewelry cleaning solution that was on the floor. Okay, B. Someone had left a 5-gallon bucket of jewelry cleaning solution in the area near the sink. The bucket had either leaked onto the floor or a spigot attached to the bucket had been left in a position that caused fluid to drip onto the floor. Okay, now this is a change. On 3 prior occasions, Portia had cleaned up fluid from the area around the same 5-gallon bucket. On each of those occasions, after Portia cleaned up the fluid, she specifically told Mr. Grantham about the fluid that had been on the floor. So it's going to be a hard time. He's going to have a hard time saying he didn't know about the latent condition, right? Because the person in this fact pattern that she told was him. Okay. The employee break room is under the exclusive control of Mr. Grantham and his employees. The break room is not accessible to the public, meaning customers, that it's not accessible to. But of course, remember under letter A, she had previously agreed with him that she was going to clean the break room. Okay. As a result of her fall, we kind of broke this down a little bit. As a result of her fall, she broke 2 bones in her right arm. Portia also broke her right hip, had to have hip surgery, and went to physical therapy for 3 months so she could learn to walk again. That said, Portia is still having trouble walking, and her doctor tells her that she may have to use a cane for the rest of her life. Gee, today she's accumulated over $125,000 in medical bills. But you got to think about how are you going to plead that given the rules as listed in the memo, right? Are you going to say it like that, or are you going to say it somewhat differently? Portia's also, and what's interesting is this goes, tell me your name again? Michael, this kind of goes to your point, which is, yes, it's about damages, but it's also the jurisdictional amount, which is something that you're probably going to want to allege at the beginning of your complaint. So my point with you was, it's mostly duty breach causation damages in that order. The story's kind of told in that order, but there might be moments where certain things have to be moved around when you're actually drafting your complaint. This fact pattern is not written in the way you would want to write a complaint. Some of these sentences you might pull word for word, but other sentences you're going to want to change to track language that's listed in the statute, right? To kind of, but not totally, because you're alleging ultimate facts, not legal conclusions, right? So we'll kind of piece that together in a minute. To date, she's accumulated over $125,000 in medical bills. H, Portia is also unable to carry on her cleaning business and has lost the profits and benefits that she otherwise would have received. I, Grantham's Jewelry Store is located at 212 Tennant Street in the city of Old Town, which is located in Caledonia County in the state of Kentucky. Probably might make sense for venue purposes, although you want to look at the memo as to whether that's something you want to be. Mr. Grantham is in possession and control of the premises at all times. Any question about that? So you see, it's kind of lengthened. Some of it's broken up. Some of it's cleaned up to kind of make it a little bit clearer what is going on. And then let's look at this memo on the practical effect of Kentucky rules. Same rules on pleading and jurisdiction and venue and damages. Signing is the same. Let's look at this though. It's a little updated here with the elements. In Kentucky, a person who owns and operates premises has a duty to use reasonable care to make those premises safe for a business invitee. Under Kentucky law, if a business owner arranges for a person to provide cleaning services, that person is considered a business invitee. Okay, so I mean, couldn't be any more like, open up. That's what happens when you have 2 kids. You're like, I want to spoon feed everybody. But yeah, and and frankly, what you would do if in the real world, if you got the last bucket of premises liability action law, the body of law that was given to you or that you discovered, you would then, in reality, you would grapple with, hey, is it business invitee? Is she a business invitee? Is she owed a duty of care? And then you would do a bunch of research. The point of this class it's not legal research, right? The point isn't to go out there and you glean under the law whether or not, individuals who provide janitorial services to businesses are owed a duty of care under a fake jurisdiction's premises liability law. The point is to be able to take law that you are kind of well aware of, that you can kind of understand, and use that to then draft a legally sufficient complaint. Okay, so the following is an outline of the elements of a premises liability action. This is also updated a little bit. the existence of a duty of reasonable care arising from the defendant's possession or control of the premises. That's the same. And then look how it's kind of broken up. Breach of duty consisting of both A, existence of the hazardous condition that the defendant either knew of or had sufficient time to become aware of. Now, it's broken up a little bit to kind of make it clear to you, hey, when you're alleging facts, I think it would be wise to allege facts that first go to the existence of a hazardous condition. So you could see if they admit or deny those, right? Like, was there a leaky fluid on the floor or was there not? Then you could separately allege whether the defendant knew of or had sufficient time to become aware of it. But you want to break it up like that. You want to break up kind of statutory or element-driven language into those chunks so that you can, in separate numbered paragraphs, allege very discrete ultimate facts that go to not just all of the elements, but within each element, you might have different allegations that you have to put forth. Does that make sense? Because I think a lot of times what I've seen before, both from students and practitioners, is they think I need to allege ultimate facts that go to each of the elements of the cause of action, which is true. The problem, though, is when one element of a cause of action kind of has multiple subparts. Like if one element is breach, but breach requires you to show both the existence of a hazardous condition that the defendant knew of or had sufficient time to become aware of, and the defendant failed to remove, repair, or correct the condition, or failed to make reasonable efforts to warn the plaintiff, breach itself might be at least 5 numbered factual allegations. Do you see that? But what happens is students think, well, it's all breach, I'll just pile it all into one. And the problem with that is, the more you include in a numbered paragraph, the more likely it is that the defendant's going to find something in there that he or she objects to and then denies the allegation. Does that make sense? Okay. 3, the breach caused personal injury to the plaintiff, and 4 is as a result of the breach, the plaintiff suffered damages. Okay, so what are you going to do? Well, you're going to do this drafting exercise, which is draft the 1-count premises liability complaint. So how are you going to start? Well, don't focus you got to have some of that, but you really kind of need to do a new analysis. You need to get out this new fact pattern, this one. And what you're going to want to do is, I would, if I were you, basically set down 3 documents. This new fact pattern, you need to have that there. And you need to have this here, these rules. And then I would almost treat as a separate document these elements. Because what you need to do is you need to take your fact pattern and you need to read over it and kind of dissect it. And in doing that, what you need to have next to it are the elements of the premises liability action. And you're going to want to try to make sure that you pull facts from this fact pattern that go to each of these elements. And you want to try to build a complaint that includes allegations that go to each of those. And in doing that, you also want to be mindful of any local rules and some of the rules of civil procedure that exist, right? So let's think, how are we going to start this? I mean, we'll kind of we've got a few minutes, we can just, it's all good faith at the beginning, right? Like the complaint, this is like a good faith effort to draft a complaint. So in thinking about that, how are you going to start your complaint? Let's get a head start on your assignment. What are you going to do? What's the first thing? You're going to do that work, but just think to yourself, well, how's your complaint going to start? What's it going to begin with? A caption like this. In the Superior Court, Caledonia County, Kentucky, right? Something like this. Now you'll probably have, we already know, it's going to be something like Portia Pond doing business as Old Town Cleaning Services, Old Town Commercial Cleaning Company, plaintiff. So Portia Pond doing business as Old Town Commercial Cleaning Company, comma, plaintiff, or plaintiff Portia Pond doing business as Old Town Commercial Cleaning Company, whatever you say there. versus Philip A. Grantham, comma, doing business as Grantham's Jewelry, defendant, right? You could put just case number here, a 1, 2, 3, ABC, whatever, ABC 1, 2, 3. And then you would probably draw a big line, right? And then how are you going to title it? This is really fun. It will get more fun. If you think this is boring, the class gets better. This is just like we have to draft a complaint. You got to be thinking about civil litigation. But how do you title it?
Premises liability.
Yeah, premises liability complaint or complaint for damages, premises liability. Maybe a premises liability complaint. I think that's fine. What's next?
Introduction.
Okay, what's another word for that? Commencement. Yeah, the commencement. Yeah, the introduction. What is that going to sound like? Mitchell, right?
Yeah.
Yeah.
Plaintiff Portia Pond sues Philip A. Grantham.
Sue's defendant.
Sue's defendant, Philip Gray.
And I sound like an ass, but the
No,
only
you-
point is the consistency,
Yeah.
right? That's the key. If you use plaintiff at the beginning there, use the defendant. If you didn't, then I think it's okay. You could say Portia Pond sues Philip Grantham.
Yeah, sues for.
You could just say sues and alleges. So you could say
Alleges,
plaintiff,
yeah.
plaintiff Portia Pond sues defendant Philip Grantham and alleges, colon, and then start. And now you're going to start numbering. What's your first one? I mean, we don't have to go word for word. I mean, what are you going to start with? Yeah, subject matter jurisdiction allegations, right? Now remember what was defective about the last one we read. It was a disaster. And all you needed is what? This goes to Michael's point. What are you going to put? How are you going to allege the subject matter jurisdiction? Are you going to say this action is for damages totaling $125,000? Why not?
Because you can't do that.
You can't do that. Why not?
Because the law in this
Yeah.
jurisdiction.
The rules prohibit that. So what will you allege?
What she said earlier.
What did she say earlier?
Exceeds the threshold or exceeds $20,000.
Yeah, this action is for damages in excess of $20,000. Yeah, good. Subject matter, that's it. Then it's where it gets more difficult. You want to start out by alleging facts, allegations establishing the existence of a duty. And this is where you're really going to have to start to sift through some of these allegations. And but the long and short of it is, you're going to want to kind of make it clear, hey, here's who the defendant is, right? Here's the business that they own and where that he owns and where it's located. Here's who the plaintiff is. To demonstrate next after that the nature of the relationship between the parties. So, you're going to want a factual allegation about who the defendant is, one or more. You're going to want a factual allegation about who the plaintiff is. And you're going to want a factual allegation about the fact that the plaintiff went to the defendant's store to provide cleaning services on such and such a date. Or on such and such a date, the plaintiff went to the defendant's store to provide cleaning services. Okay? Those all go to duty, right? So you're taking your duty law and you're putting numbered factual allegations that go to that element. Notice nowhere in there are you saying, and thus the defendant owed the plaintiff a duty of care. Now I say that. Could you say that though? I think you maybe could do that. You could do that. But the point is that's not what the purpose of the complaint is. See, before this class, maybe you knew this. And again, this is like the least sexy part of the class, right? Like this isn't the most fun part. But you may have come in here thinking like, oh, we're gonna like in a complaint have to prove duty and prove breach. And it's true you do, but you do it through factual allegations. You don't do it through, oh, I'm going to argue to you that there's a duty. I'm going to argue that there is a breach, right? It's not like torts class where, hey, Because this could be, you could imagine this being like 1L torts. Here's your negligence fact pattern. Tell me whether Portia Pond has a viable cause of action for premises liability. Can she prove up a negligence claim? And you would be all about, like, the first issue is duty. Under the law in Kentucky, a person who owns property, you know, has a duty to use reasonable care, blah, 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 under Kentucky law. And then you would have, apply to these facts, blah, 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 blah. In conclusion, Grantham owes her a duty of care. That's how you would analyze a set of facts and come to a conclusion about whether or not each of the elements are met. What's interesting is, for purposes of a complaint, you're just writing the factual allegations in a very neutral way with the law to the side, but that's not really creeping into the complaint. Do you see that? I know that sounds like easy, and you would be stunned how many lawyers' complaints are, first of all, look like this awful one, but more importantly, are just riddled with statements of law, right? But that's not what the purpose of a complaint is, right? In a way, it's almost fair to like assume that the reader, the defendant, but also the court to some extent, you also, in a way, are kind of assuming that they just know the law, right? That they're kind of going to be able to read this and kind of acknowledge that these are the elements that are going to go to duty. These are the, oh, okay, duty, breach, without those words being in there. Now, all of that said, that's not to say you couldn't include the words duty or breach or causation or damages in your complaint. Where might you include them? There's kind of two ways I can think of it. Still, despite what I just said, you may be still including them. Does any of this, is this making any sense? Some of you look like disturbed. Maybe it's just me. Do you know what I'm saying? Does this make sense?
I think last time you said we could use them as like a segue into the next.
Yeah, I think that's one way you could do it, right? You could say something like, you could do it at the beginning or the next one. You could say, the defendant, you would actually write the word defendant, don't put a triangle. You would say the defendant, or Philip Grantham, owed the plaintiff a duty of care. Number one. Number two, so the defendant owed the plaintiff a duty of care. Now this runs afoul of the rule in the book, right? This is like a legal conclusion. This is like Michael, right? It's Michael? Yeah, Mark. So no, it's not Michael. Mark told me, right? You need to have ultimate facts. You don't want to have legal conclusions. This is a legal conclusion. I'm now telling you, maybe you could include that in your complaint. But you would, one way you could do it, as April suggests, is as a segue into the ultimate facts, right? You would then want something like, well, the defendant owned a grocery store named Grantham's Jeweler, or not a grocery store, whatever, jewelry store named Grantham's Jewelry Store located at this. And that would be an ultimate fact. And then you would say the plaintiff ran a cleaning company known as this. Fourth, on this date, she went to provide very discrete ultimate facts that would easily be admitted or denied. And so then the question is, well, what the hell function is this serve? Why have this? Well, it's like a roadmap. Do you see that? Right? It kind of just orients you, the plaintiff's attorney, or maybe the reader, the defendant even. Like, you're providing a little bit of a service to them. Like, hey, this is the duty stuff. Or the court, like, oh, okay, you're alleging duty here. And this is why, and this is why. These go to the element of duty. That's one way you could do it, right? Another way you could do it is to not put this in here and maybe do A, So you gotta be a little careful. I don't know about that. 1, 2, 3, because then the question is if you do a B, is it then 4? I think you've got to stay sequential, right? What I kind of like a little better is something like this, just a word. Duty. Because then it's really not, I don't know that that's technically allowed, but it's there, like duty. Now I'm going to allege things that go to duty. Why do you do it? Why might you do it? You might do it because you're new at this and you need the comfort, right? You need the like blanket of, I want to make sure I have enough factual allegations that go to each of the elements. Maybe what you do is that you do it all, right? Maybe down here you've done, then you have breach. Maybe you do it like this, where you literally put brackets around it. And then maybe you get to the very end and you finished it all and then you delete them. Do you see what I'm saying? I'm trying to be kind of funny in a way, but what I'm trying to tell you is there's not, like what, I mean, this is like full disclosure now. The teacher's manual puts them in brackets. Like subject matter jurisdictions, duty, breach, causation. I think it could make its way into the complaint. The point is it's not doing any real work for you. That's not helping you win your case. They're going to, to the extent you actually plead that, they're going to probably deny most of those allegations because, like the book tells us, they're legal conclusions. But it's like headings or Roman numerals, or I like some of that stuff because I think it orients me when I'm drafting something. I like the fact that I've hit all of my bases, right? It goes back to that idea that I talked about early in one of the last few classes about, when you take an exam and you jot down your outline real quick, it makes sure that you don't leave something off. And while that may not sound significant, it can be very significant because if you don't include allegations that go to all of the elements, what's going to come back, Mitchell? If you don't include a failure to state a claim. So that's why it can be very helpful to you to be like, oh, duty, breach, causation. I'm not worried that for our purposes you're going to forget that, but it's just a life tip, which is you can include legal conclusions in your complaint, but you need to recognize that they're not actually doing any work for you other than orienting you and another reader. So now I've beaten a dead horse, but I think you get the point. Any questions about that? So it's up to you. I would maybe include them, just like duty, breach, causation, damages. I think it could help you. If you don't want to, that's okay, that's fine too. What's interesting is, in the manual, not only do they put like things like subject matter jurisdiction, just for the purposes of orienting them, right? Professors Temple, Smith, and Couples, they also, within elements like breach, they even put some of the subheadings like existence of the hazard. I mean, these are two law professors who are a lot smarter than me, right? And have much more experience drafting civil documents. They feel the kind of security blanket of legal words, right? So I think it's fine if you include that too. But notice they keep their factual allegations kind of consistent, right? I also think some of this is poorly graphed. Notice I've like started scratching it out. But anyway, who the hell am I? And I mean, it's all good faith. There's no, it's not like one person, Amy's gonna get it, and you all can't. Like, Amy's complaint might be excellent, and it could look very different than Mitchell's, and that's okay, right? I mean, Amy's is probably gonna be better, but what can you do? Somebody did. But no, I mean, seriously, they will look different. Everybody will have their own style. Some people will include headings, some people won't. Some people will have a slightly longer allegation, some people won't. Some people will use a little more of the active voice than others. But take a stab at it. So that's really all I've got. The only other note, just give me 2 minutes. So you'll do that, right? You'll look at this new kind of set of factual allegations that's been updated. You'll look at the updated memo. You'll try to draft a complaint. You'll turn that in by Saturday at 5. And then you will turn your attention to the next reading assignment, which has already been posted, which is on answers. And that is here. Let me just run through that real quick. It gets better. I mean, this stuff, it complaints and answers. I mean, I don't know. Maybe it could be more fun, but I'd like to just teach like an advanced legal writing class, which is basically how I turned the second half of the class into. This gives you a good sense though, like of admissions, denials. This will kind of be a really kind of comprehensive reading assignment on if you have a complaint, how do you properly respond to it in a defensive way? And not only will you be thinking about things like admissions and denials, but it also starts to get into things like affirmative defenses and how do you plead those? And it includes things like assumption of the risk or, some of the other things like contributory negligence that we've discussed. But we'll focus on drafting an answer next time for the next week after we've had a chance to kind of thoroughly discuss this. So draft your complaint, turn those in good faith by Saturday at 5, and then turn your attention to this reading assignment, which isn't too long. All right, guys. I hope that was not too terrible. See ya.